It was a routine hearing in Courtroom 3B of the Jefferson County Courthouse. The Honorable Judge Marlene Carter, a widely respected legal authority with over 2 decades on the bench, presided over a misconduct case involving a local police officer. The defendant, Officer Daniel Krell, stood at the defense table, arms folded, his face taut with barely concealed contempt. His record showed a history of disciplinary warnings, insubordination, use of excessive force, and an ongoing pattern of questionable behavior in the field. Judge Carter questioned Krell's recent actions during an arrest gone wrong, one that had led to the hospitalization of an unarmed citizen. Her tone was measured, her questions direct. "You've been here before, Officer Krell. Why is your conduct consistently at odds with department policy?" Something snapped. In an instant that stunned the room, Officer Krell stepped forward and struck Judge Carter across the face. Gasps echoed. A bailiff rushed to intervene. Court clerks froze in shock. Reporters, already in attendance, scrambled for their phones. But Krell's expression didn't show remorse. His eyes burned with disdain, as if he believed himself untouchable. He was wrong. The silence in the courtroom shattered as uniformed officers surged forward. Bailiff Thomas Reyes, a former Marine and long-serving protector of the court, tackled Officer Krell to the ground within seconds. Judge Carter remained upright, though visibly shaken. Blood traced a thin line down her cheek, but her posture did not falter. She raised one hand, not in defense, but in command. "Restrain him. Now." Krell was cuffed on the floor of the very courtroom where he had expected to dodge accountability. As he struggled, muttering under his breath, the irony of the moment was lost only on him. Outside, news of the assault spread like wildfire. Cameras were already rolling when Krell was escorted out through the courthouse lobby, flanked by deputies. No special treatment. No shield from judgment. Just a man in uniform facing the consequence of his own actions. Within the hour, the courthouse issued an emergency statement condemning the assault on a sitting judge. The Chief Justice of the state Supreme Court personally called Judge Carter to express solidarity. "This was not only a violation of your person," he said, "but of the integrity of our judicial system." Krell was taken to a holding cell. A new judge was appointed within minutes to preside over his bail hearing, which, given the violent outburst, was swiftly denied. Meanwhile, Judge Carter insisted on finishing the docket for the day. Her message was clear: she would not be silenced, shaken, or sidelined. The morning after the assault, the Jefferson County Courthouse stood beneath a sea of news vans, protest signs, and a growing crowd of citizens demanding accountability, not just for what had happened to Judge Carter, but for the system that allowed Officer Krell to act with impunity for so long. Inside the courthouse, an emergency judicial panel convened to begin an internal review. This wasn't just a matter of courtroom decorum, it was an unprecedented breach of legal and civic order. A law enforcement officer had struck a sitting judge, in her courtroom, during a public hearing. The panel, composed of judges, legal scholars, and senior members of the state bar, turned its focus to deeper questions. How had Officer Krell remained on the force despite repeated behavioral flags? Who had protected him from disciplinary action in the past? Were there others in the department who shared or enabled his disdain for oversight? As the investigation widened, troubling details emerged. Anonymous complaints had been filed against Krell over the years, many of them mysteriously shelved or lost. Several officers who had once partnered with Krell came forward, describing his aggressive attitude toward authority he didn't respect, especially authority that didn't look or think like him. Again and again, the same pattern: defiance, aggression, and a belief that his badge placed him above reproach. Judge Carter, for her part, remained composed in public but resolute in private meetings. She declined interviews, but released a short statement: "This is not about me. This is about the dangerous illusion that some individuals carry, that their uniform excuses them from the rules. It does not. And it never will." Within a week, the city's Civilian Oversight Board launched its own inquiry, spurred by public outcry and media pressure. Whistleblowers inside the police department confirmed what many suspected: Krell had long been shielded by senior officers, some of whom viewed any form of external accountability as a threat to the force. Meanwhile, public support for Judge Carter swelled. Letters poured in from around the country, from fellow judges, community leaders, former defendants who credited her with giving them a fair hearing, and ordinary citizens outraged by the attack. The district attorney, under intense scrutiny, announced a full criminal prosecution against Krell. Charges included felony assault on a public official, obstruction of justice, contempt of court, and threatening the integrity of the judicial process. The judge overseeing the case ordered it moved to a neutral jurisdiction to avoid any appearance of conflict. Officer Krell, now stripped of badge and title, sat alone in a jail cell. No longer a symbol of authority, just a man awaiting trial. The trial of Daniel Krell began under unprecedented public scrutiny. Held in the neighboring capital city to ensure impartiality, the courtroom was packed daily with reporters, legal observers, and members of the public, some arriving before sunrise just to get a seat. Live-streamed and heavily covered by national media, the proceedings had become a flashpoint in the ongoing debate about unchecked authority, institutional loyalty, and the limits of personal bias within public service. Krell's legal team attempted to paint the assault as a moment of emotional instability, blaming stress, media pressure, and even claiming provocation. But surveillance footage from the courtroom left little room for interpretation. Krell had approached the bench in full control of his movements and struck a sitting judge without hesitation. The prosecution, led by Assistant District Attorney Elena Ruiz, took a different approach. She didn't focus on Krell as just an individual who lost control. She laid out a pattern of entitlement, disdain for institutional oversight, and habitual disrespect for figures of authority who dared question him. This case, Ruiz said in her opening remarks, is not only about a single violent act, it is about a belief system. One that festers when people in power are not held accountable. One that teaches certain individuals that they answer to no one. Over the next 2 weeks, damning evidence mounted. Internal department emails showed a concerted effort by Krell's previous supervisors to bury complaints to avoid bad publicity. Anonymous testimonies revealed how junior officers were told not to snitch on Krell or risk being ostracized. A few even broke down on the stand, describing the culture of silence and protection that enabled Krell's behavior. Judge Carter testified on the 5th day of trial. She entered the courtroom without security escort, calm and composed. Her testimony was brief but powerful. I have sat across from gang leaders, fraudsters, and people who have committed unspeakable acts. I have never feared for my safety in this courtroom, until that day. Not because of the man in front of me, but because of what he thought he could get away with. Her words hung heavy in the room. Public sentiment continued to swell outside. Civil organizations, legal associations, and community leaders gathered in peaceful solidarity, not just for Judge Carter, but for institutional reform. Discussions of accountability boards, police oversight, and ethical review committees surged into mainstream discourse. When the jury returned after 2 days of deliberation, the verdict was unanimous: guilty, on all counts. As the sentence was read, 12 years in a state penitentiary without parole, Krell's composure cracked for the first time. No applause followed, only silence. A long, heavy silence that marked not just the end of the trial, but the closing of a chapter that had tested the very spine of the justice system. Yet the real impact wasn't just the conviction. In the months that followed, the police department's internal affairs division was overhauled. Several officers resigned or were dismissed for their roles in covering up misconduct. Judge Carter was invited to lead a statewide task force on institutional ethics and courtroom security. State lawmakers passed legislation to increase transparency in departmental complaint reviews. And in classrooms, bar associations, and civil forums across the country, the case was studied as a turning point, a reminder of what happens when systems protect power over principle. Judge Carter continued her work, refusing to allow the assault to define her. In interviews, when asked how she endured it, she answered plainly, "I didn't endure it. I faced it. Like every person who sits in front of me, flawed, human, and accountable. Months passed. The courtroom where it all began was renovated, not because of the physical damage, but because of what it had come to symbolize. New security protocols were implemented. A reinforced bench was installed. Yet the most powerful change was intangible, a deeper, more vigilant culture of accountability. But the aftermath of the Krell incident rippled far beyond the courthouse. Judge Carter's return despite suggestions from advisors to take extended leave or request a transfer to a quieter circuit. Judge Marlene Carter returned to her bench just 8 days after the attack. She arrived early, without fanfare, entering through the public doors alongside jurors and attorneys. Her first hearing that day was a parole review for a young man who had once appeared before her on burglary charges. He paused upon seeing her and said, "I didn't think you'd come back." Her response was quiet but firm: "Justice doesn't retreat." Her courtroom became a place of renewed purpose. Litigants and attorneys alike noticed a slight shift, not in her rulings, which remained fair and impartial, but in the sense that this space had survived something. That it now stood not only for the law, but for resilience in the face of aggression cloaked in authority. Community reckoning in Jefferson County, citizens began looking inward. Conversations erupted, not only about law enforcement, but about silence. About who gets protected, and who gets punished. Community meetings tripled in attendance. For the first time in decades, the Police Oversight Board included citizens under 30, members of immigrant communities, and public defenders. Churches and schools held open forums, inviting people to share stories of mistreatment that had long gone unspoken. The phrase, Krell Protocol, became shorthand for the new set of state-level reforms requiring all officers to undergo regular psychological assessments, body cam audits, and third-party review of force complaints. Several states followed suit, replicating the legislation with their own variations. The quiet backing away of those who once supported Krell, the ones who had called him just tough or misunderstood, was equally telling. In private, they distanced themselves. In public, some refused to comment. But their silence was interpreted not as neutrality, but as complicity. Personal cost privately, Judge Carter dealt with the toll. There were nights she woke from sleep, her hand instinctively brushing the left side of her face. She'd never admitted it openly, but for weeks, she found herself flinching at sudden movements. Therapy helped. So did long walks and the letters, hundreds of them, from strangers who called her a symbol of dignity. Still, she never claimed healing as a finished process. Her family, too, bore the weight. Her daughter, a second-year law student, told a professor she no longer wanted to be a judge. "I don't want to go through what my mother did," she said. Judge Carter gently corrected her. "You don't inherit fear. You inherit the strength to overcome it." Krell's final statement at his sentencing hearing, Krell had been offered a chance to speak. He refused. But weeks later, a letter surfaced, leaked from within the prison, addressed to no one in particular. It wasn't an apology. It was a manifesto. In it, he claimed to be a victim of a broken system, accusing the court of caving to public pressure, and calling Judge Carter a symbol of weakness masquerading as justice. The letter only confirmed what many already believed, that Krell's violence hadn't been spontaneous. It had been a culmination of resentment, of delusion, of unchecked defiance reinforced by years of never hearing no. The larger shift nationally, the legal system faced hard questions. Seminars were held on institutional arrogance. Judicial conferences discussed implicit bias not in abstract, but through real-life case study, this case. Law schools updated their ethics curriculum. Bar associations issued new guidelines for courtroom conduct, not just for attorneys and witnesses, but for law enforcement officers participating in judicial proceedings. One senior judge, during a keynote at a national conference, said, "The courtroom is the one place where power must bow to principle." What happened to Judge Carter wasn't just an attack on a person. It was an attempt to tip the scales of justice by force. And the system, this time, held its ground. Legacy Judge Carter never sought to become a public figure. She refused book deals, turned down media profiles, and declined invitations to political office. Instead, she stayed on the bench, ruling case by case, name by name. And yet, her image, standing firm in her robe, just moments after being struck, became an enduring symbol. Not of victimhood. Not even of triumph. But of clarity. That truth, courage, and accountability are not abstract ideals, they are daily decisions, made in silence, under pressure, and often at great personal cost. And that justice, though tested, had not wavered. Time, as it always does, moved forward. News cycles shifted. The headlines that once blazed the name Daniel Krell across every screen faded, replaced by the next crisis, the next scandal. But in Jefferson County, and in the lives of those closest to the courtroom that day, the impact of what happened didn't fade. It settled. It reshaped. Years later, 5 years to the day after the courtroom assault, a bronze plaque was quietly installed just outside Courtroom 3B. Not a statue. Not a monument. Just a simple engraving mounted to the wall. It read, "Here, on this bench, justice stood against intimidation. Truth was struck, but not silenced." The initiative came not from a political committee or an advocacy group, but from a group of law students, many of whom had been inspired to enter the profession after witnessing Judge Carter's composure and leadership in the aftermath of the incident. They raised the money themselves. Judge Carter never requested it, and only found out when she was invited to the modest unveiling. She didn't speak at the event. She simply placed her hand on the plaque and nodded. A new generation. Judge Carter's daughter, Maya, did graduate from law school. She initially hesitated to take the bar exam, but eventually did, passing on her first attempt. When she announced that she had accepted a clerkship with a federal judge, she sent her mother a short message, "Not because I want to be like you. Because I understand now why you stayed." Maya would go on to advocate for judicial safety reforms and mentorship programs for underrepresented students interested in law. Her voice was different from her mother's, fiercer, more public, more restless, but the same principle anchored both: authority is not a crown, it's a responsibility. The officer forgotten, but not as for Daniel Krell, his name became a warning in law enforcement training seminars, a real-world example of what happens when personal resentment is left unchecked, when oversight is seen as betrayal, and when arrogance is mistaken for strength. He remained incarcerated, his appeals unsuccessful. Occasionally, tabloids reported on his disciplinary infractions within prison, altercations, refusals to comply, his continued belief that he had been set up by a system he still didn't understand. But among the public, he became a ghost. His name no longer evoked fear or controversy. Only failure, a cautionary tale that lingered in the minds of officers, judges, and public servants. Cultural shift in the legal and civic world, the legacy of the incident matured into something useful. Judicial security measures were not only improved, but humanized. Officers assigned to courtrooms received training in de-escalation, but also in recognizing authority they were not allowed to challenge through force or disdain. A surprising number of officers wrote anonymously to local newspapers, expressing regret for not speaking up about Krell sooner. Some said they had been afraid, others admitted they didn't realize how deep the rot had gone. These letters sparked broader conversations about internal silence, not just in law enforcement, but across all professions. A school in Jefferson County launched a program called the Carter Principles, teaching students the values of composure under pressure, listening before judgment, and standing up against institutional inertia. Judge Carter's final term. When her third full term neared its end, Judge Carter chose not to seek reappointment. She had spent more than 25 years on the bench. She gave no interviews. No farewell speech. She simply finished her last docket, signed the final case order, and packed her things into a small gray file box. But the courthouse was not quiet that day. Law clerks lined the hall. Officers, including several who had joined the force after Krell's trial, stood at attention. Attorneys paused their proceedings to step out of courtrooms and applaud. Not because she was leaving, but because she had remained, when so many others would have walked away. She passed them all, offering a gentle smile, pausing only once, to look again at the small bronze plaque outside courtroom 3B. This time, she placed her hand to it for a moment longer. No words. Just memory. Weight. Meaning. A closing thought. There is no tidy end to a story like this. No single law that repairs every broken part of a system. No sentence that erases trauma. But some moments cut through the noise of politics, ambition, and fear. Moments where a person says, "Not here. Not like this." And the world, even for a moment, listens. Judge Carter never wanted to be a symbol. She wanted to be fair. To do her job. To apply the law. And perhaps that's the most remarkable part. That in refusing to become larger than life, she became exactly what justice is supposed to be: steady. Unmoved. And deeply, fully human. As the sun set over Jefferson County, the courthouse stood quietly, a sentinel of law, order, and the ideals that Judge Marlene Carter had fought so hard to protect. The events that had shaken its halls still echoed, but not as a source of fear or division. Instead, they served as a solemn reminder: justice is a living, breathing practice that requires constant courage and vigilance. In the years since the incident, many had tried to capture the essence of what happened: the strike, the trial, the reforms, in speeches, articles, and lessons. Yet the truth remained simpler and deeper than any headline or legal precedent could express. Judge Carter once said in a rare public interview, "Justice is not a shield we hide behind, nor a weapon we wield. It is a promise, to each person who walks into a courtroom, that their voice will be heard fairly, their rights respected, and their dignity preserved. Even when challenged, even when shaken, that promise must never break." Her words became a guiding principle for a new generation of judges, officers, lawyers, and citizens who understood that the struggle for fairness was ongoing and that accountability was not a punishment but a safeguard. The story of the officer who struck the judge was no longer just about one man's failure. It was about the strength of a system willing to confront its own flaws, to listen to uncomfortable truths, and to uphold the balance between authority and responsibility. In the end, the courthouse wasn't just a building, and Judge Carter wasn't just a person. They became symbols, not of perfection, but of perseverance. For justice, like those who serve it, endures because it is chosen, again and again, by people willing to stand firm when it matters most.